Forum for Democracy and Development ఆశ్రయంలో ఈరోజు చట్టబద్ధ పాలన భారత ప్రజాస్వామ్యము అనే అంశంపై చర్చాగోష్ఠి ఏర్పాటు చేసినందుకు ఫోరం ఫర్ డెమోక్రసీ మరియు డెవలప్మెంట్ పదాధికారికులకు మరియు అందరూ సదస్సులకు మనమందరూ కూడా అభినందనలు చేయాలి. కారణం ఏమంటే ఈనాడు దేశం అంతా ఈ చర్చాగోష్ఠి చట్టబద్ధ పాలన మరియు భారత ప్రజాస్వామ్యం పైన ప్రస్తుతమైనట్ల విషయము, దీని గురించి ఎక్కువగా చర్చ చేసి ప్రజానీకానికి తెలిపేట్లా విషయాలు చాలా ఉన్నాయని ఇప్పుడు తానే మన అధ్యక్షులైన డాక్టర్ ఎస్ జయప్రకాష్ నారాయణ గారు వివరముగా మనకందరికీ చెప్పినారు. ఈ సభకు వాళ్ళు అధ్యక్షతని వహించారు. మరియు ఈ విషయాన్ని గురించి మాట్లాడే భాషణకారులు అయిన కెఎస్ లక్ష్మణరావు గారు, ఆంధ్రప్రదేశ్ శాసన మండలి సభ్యులు, మరియు ఆంధ్రప్రదేశ్ మాజీ అడిషనల్ అడ్వకేట్ జనరల్ గారు మరియు సీనియర్ అడ్వకేట్ అయిన ఏ సత్యప్రసాద్ గారు, వేదిక పైన ఈ ఫోరం ఫర్ డెమోక్రసీ అండ్ డెవలప్మెంట్ కారణీభూతులైన సూర్య గారు, ఈ సభలో భాగవహించేట్లా పెద్దలారా, వకీలులారా, విద్యార్థి మిత్రులారా, శుద్ధి మాధ్యము చిత్రమాధ్యము స్నేహితులారా, చట్టబద్ధ పాలన భారత ప్రజాస్వామ్యం అనేట్ల విషయము చాలా ప్రస్తుతమైనట్ల విషయము ఈనాడు. ఇది చాలా అవసరంగా మనము చర్చ చేసేట్లాది పరిస్థితి మనకి ఈ దేశంలో వచ్చింది. ఈ విషయాన్ని గురించి మీ అందరూ పర్మిషన్ తీసుకొని కొన్ని విషయాలని ఆంగ్ల భాషలో మాట్లాడతాను. ది క్వింటెసెన్స్ ఆఫ్ డెమోక్రసీ is rule of law and constitutional governance. The visceral understanding of what is rule of law presupposes distinguishing it from the rule by law. A rule by law implies that law is an instrument, a tool at disposal of the ruling dispensation. The government in power and that government is considered above the law. On the other hand, a rule of law implies that everyone is in society is equally bound by the law, including the government, and the law is above the government. It is the duty of every citizen to be an alert observer of the current state of affairs in our constitutional democracy and independently assess whether rule of law prevails in our nation today or whether it is ruled by law. History is testimony of the fact that unbridled power often has cataclysmic consequences. Essentially, constitutional limits on power, a key feature of a democracy, require adherence to the rule of law. The United Nations Secretary General Kofi Annan, in his 2004 reports on the rule of law, stressed that for the United Nations, the rule of law is, I quote from the report, a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure adherence to the principles of supremacy of the law, equality before the law, accountability to the law, fairness in application of the law, separation of powers, participation in decision making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. Each one of the aspects which has been dealt with in this report by the then Secretary General of United Nations is blatantly violated in the governance of the country by our governors. Governors is not governors of a state. That is the Union of India, state governments, local self-governments. They have been violating the rule of law. The emphasis is made by Dr. Jayaprakash Narayan that the law is required to be implemented, and decentralization of power is very much required in a country like ours, though the Constitution by 73rd and 74th Constitutional Amendment way back in the year 91 came into force from January 1977, the decentralization of power has not given any impact in the democratic India. Yes, Part 8 and Part 9 exclusively deals with the decentralization. That we have to understand, keeping in view the direct principles of the state policy. Dr. Ambedkar, while debating the draft constitution, article by article in the Constituent Assembly, he has referred to Article 40, the village republic, panchayat system, is a miserable failure of village republic in India. The 73rd and 74th Constitutional Amendment, with the avowed object, the power must percolate to the rural India. For that, local self-government, the panchayat raj system, the municipalities, municipal corporations must govern the people who are duly elected from among the people. There are instances in every state, more particularly in this state, I have been told and heard in the debates that the funds which are earmarked by the Union of India in its budget for the development of rural India and the local self area is being utilized by the state government, not release that fund for the development of the local area. This is a failure. That is to state, decentralization in the Constitution is there, but decentralization in implementation is a big failure. That's why a seminar like this, debate on this subject, and public opinion is required to be generated, and we have to educate the members of the village panchayat, the members of the municipality, the corporate councillors, and corporators of the municipal corporation. Unless we educate them, their role to participate in strong development of the rural area by utilizing the funds which have been earmarked for them, the decentralization of power under the constitution is meaningless. So therefore, the emphasis rightly made by Jayaprakash Narayan, decentralization is very important. Centralization of power, either for the central government, Union of India, or for the state government, is not good. A country like ours, where 140 crores population and geographical area, of course, it is lesser than compared to United States of America. Nonetheless, 140 crores from Jammu Kashmir to Kanyakumari is a big country. Each state itself is a country. Therefore, a decentralization must be enforced. It must be implemented by letter and spirit. For that, we are required to educate our members of the Gram Panchayat, municipality, municipal corporations. All these facets of the rule of law are deeply entrenched in our constitutional fabric and are indispensable to the health of our democracy. See, the another problem in this country is constitution document is a political document as said by 7-judge bench of Supreme Court in Bommai's case. Earlier to that, in Keshanam Bhakti's case, way back in 1974 Supreme Court, 13-judge bench, after interpreting the provisions of the Constitution, Supreme Court said it is an organic document. The Constitution is an organic document. Several conceptions of rule of law have captured the imagination of several eminent jurists across the sands of time. From DC to Lord Bingham, a variety of formulations of principles informing the concept of rule of law have been made. In view of paucity of time, I would like to focus on core 4 principles given the current state of affairs in our nation and across the globe. The first principle is that laws must be clear and accessible. Laws are very clear. Laws have been interpreted by Supreme Court right from 1950. First case is Gopalan's case. Article 14 and 19 and 21 differently interpreted by the Constitutional Bench, except the dissenting view by the senior Pazhalali, Justice Pazhalali. Thereafter, 1963, evolution of law had taken place by interpretative process by the apex court. So therefore, law is not, if there is ambiguity, it can be interpreted by the constitutional courts. That has been done. But law to enforce, to implement, and particularly the part 3 and part 4 of the Constitution, the mother law, that is fundamental rights chapter and directive principle chapter, both constitute the human race. Most of the people, majority, substantial number of the population of this country, they don't have the idea of what are the human rights conferred upon the citizenry of this country. Implementation aspect is very, very minimal. The flagrant violation of the fundamental rights today. the blatant violation of the human rights. A classic case is Sri Kappan, the journalist who is from Kerala, who was doing his journalism in Delhi. 2020, he was traveling to the Uttar Pradesh state to report a case of a scheduled caste girl has been raped by powerful persons. She died in the hospital. He was traveling, he was arrested. He was arrested under the UPA Act, kept in the judicial custody without bail for more than 2 years. Supreme Court granted the bail. After granting the bail to him, 3 months later, Allahabad High Court has taken 3 months to grant bail in respect of other cases. So that speaks volumes. Article 19, freedom of speech and freedom of expression guaranteed to a citizen. I am giving a classic case of Siddharth Kappan. Like this, lakhs of citizens have been deprived the freedom of speech, arbitrary exercise of power by the executive, not considering exercising the power conferred upon the judiciary, is the classic case of not following the law, is a classic case I wanted to bring it to your notice. The second principle relates to idea of equality before the law, which includes equal protection of law as is contemplated under Article 14 of the Constitution of India. Article 14 speaks of the equality and equal protection of laws. Article 15 speaks of irrespective of the religion, the caste, the creed, sex and color, there must be equality. Both Article 14 and 15 have been completely ignored insofar as the women are concerned. The women constitute 50% of the population of this country. Till 1956, insofar as Hindus are concerned, the law which has been enacted by the parliament regarding the succession to the property, Hindu Succession Act 1956, Section 6A, till N.T. Ram Rao was the chief minister of this state, woman was not treated as a co-partner. Following the Andhra Pradesh, the United Andhra Pradesh government, N.T. Ram Rao's regime, the chief minister, introduced the bill amended to the Hindu Succession Act. That was followed by the Karnataka Legislative Assembly. They also amended in the year 1991. So these are only 2 states where the right was given to the woman co-partner. That means after we became independent, Constitution speaks of equality, equal protection. 14 and 15, the woman has not been recognized. So therefore, the mother law, the constitutional law has not been implemented for more than 40 years. Insofar as 2 states are concerned, insofar as India is concerned, till 2006 the parliament, 2004 parliament amended section 6A amendment, the woman has not been treated as a co-partner in respect of the ancestral and joint family property. So therefore, there is the discrimination, arbitrariness and equality and equal concept has not been implemented insofar as the woman is concerned in our country. The second principle relates to the idea of equality before the law, which includes equal protection of law as is contemplated under Article 14 of the Constitution of India. The third principle is that members of society have the right to participate in the creation and refinement of laws. Participation in democracy, if no participation, the democracy will fail. That's what exactly happened in this country. The principle of participation of the people, the refinement of laws will not be there. I always emphasize the fact that there is one office that ought to be most powerful in a healthy democracy, and that is the office of citizen. How many people know that adult franchise is very, very sacrosanct? We have reached a stage today, the President rightly pointed out, today the general elections either for the Parliament or for the Legislative Assembly, you are required to spend 50 crores to get elected. It speaks the mobocracy of democracy. It is not democracy, it is a mobocracy, and it is a criminalization of politics in India. If criminalization of politics in India, as he has rightly pointed out, they have invested 50 crores. If invested 50 crores, they are required to earn 5 times, 10 times the assets are seen for legislators. It speaks volumes. The PCR Act, Income Tax Department, Enforcement Directorate are all farcical institutions today. Only they pick and choose to raid and initiate proceedings. The Prevention of Corruption Act is amended in the year 2018. The giver and taker both can come under the purview of the Prevention of Corruption Act. How many cases the persons who have amassed wealth getting elected as the representatives of the people to govern the people under the Constitution, amassing the wealth, how many politicians? I wanted to mention here, now the Supreme Court in the year 2017, exclusively for the politicians who are the parliament members and the legislators who are involved in the Prevention of Corruption Act, disproportionate assets, a separate special court is required to be constituted. Direction was given by the apex court to finish the case within a year. How many cases are finished? How many cases not finished? The people are in the power. Most of the people, number of people are the parliament members. Number of the people are legislative assembly, including the chief minister of a state. Can this be tolerated? Can this be called as the rule of law? This is absolutely detrimental interest to the development of a country. Social development, economic development, progress of the country will stall if this kind of the rule of law in this country. So my dear friends, time is very short. I have got lot of material. I don't want to give a lengthy speech. The historical evolution of the rule of law, the Greeks believed that although the proper purpose of law was to advance the common good, they underscored that in practice laws were written, implemented to advantage of the privileged class of the society. This is what is happening today. The developers, I am not against the sustainable development. The developers in every metropolitan city today and the legislators amending the land reforms law, amending the APMC Act, the prohibition of alienation of agricultural land to the non-agriculturists with a ceiling that has been completely go by. Urban Land Ceiling Act has been repealed in the year 1999. So these are all laws which have been made to implement the directive principles of the state policy, part 4 by the Parliament in the year 1976. 11 states have passed the resolution, authorized the parliament to enact the law, Urban Land Ceiling Act. And the Land Agrarian Reforms Law has been brought in the 9th schedule. But all these enactments today has been a go by the non-implementation of the part 4 of the directive principle of state policy to, in the interest of the common good, as contemplated in Article 39B and C, has given a go by. That is detrimental interest. Today, if you see the statistics, the parliament member, more than 200 people, more than 200 are the industrialists they represent. How many agrarian? It is more than 67-68% of the population is the peasants. How many of them are represented in the parliament? How many of them are represented in the Indian legislative assemblies in the different states? So that means the rule of law is implemented to advantage the privileged class of the society. They constitute the privileged society. The latest, the paper publication and the American, the company made a study, the Adani company, where Hindenburg, that today is speaking volumes. LIC and State Bank of India, the investors' money, how it has been inflated, the shares have been inflated, how that was an inquiry giving opportunity to the company, Adani company. 88 questionnaire was prepared. 88 questions were not answered. 38 questions were not answered. After giving opportunity, I am only telling that the advantaged persons, the law is implemented. The question that arises then is whether it is better to be ruled by the best men or the best laws. Plato believed that the rule of law was inferior alternative to rule by men. However, Aristotle approached the issue pragmatically and noted that it mattered not only on the type of the law but also the type of regime that enacted and administered the law in question. For example, a state could choose to uphold the interest of the rich, simultaneously violating the human rights of the poor and vulnerable citizens. The tribal area, people were living. Act was enacted in the year 2009. Forest Dwellers Act. They are living. They have not seen the light of the day. Their children not got educated. They are not employed. They have not become the politicians. They have not become the judges. They have not become the scientists. Law is made to protect them, but tribal people have been, the human rights, their livelihood has been deprived of by throwing them away from the tribal area. This is the affecting the large number of the scheduled caste, scheduled tribe. And PTCL Act, both in Andhra Pradesh, United States, Andhra Pradesh, land grant was granted in favor of the scheduled caste and scheduled tribe. They constitute a class by themselves, suppressed and suppressed for 5,000 years. These people's property, which was alienated for a song, Act was enacted in my state, Karnataka state, in this state also 1974. Orissa state, where I was the Chief Justice, law was enacted to give back that land. Granted land is alienated in violation of the terms and conditions of the grant, it is void. They are required to be resumed and restored to the scheduled caste and scheduled tribe. Yes, thousands of acres of land in Andhra Pradesh, thousands of acres of land purchased by the affluent persons. The law has been interpreted by the Supreme Court. Section 11 of my enactment of the State PTCL Act, the contravention of the terms and conditions is void. It is our statutory void. There is no limitation. Section 11 of the Act says There is no limitation. You can file. It is the duty. Beneficiary is the purchaser. But the interpretation is made in the year 2018. No limitation act is applicable. Supreme Court says it is applicable. So this, we also interpret the law. Evolution of law is taking place. A.K. Gopalan's case is the proletariat leader. The interpretation 14 and 19 during that 1950 period is different. Now it is different. Insofar as the scheduled caste and scheduled tribe people are concerned, the Supreme Court in Manjegowda's case, way back in the year 1984, the constitutional validity, 3-judge bench, Justice Bhagavati upheld. Now, the very same section 11 fell for consideration. Supreme Court interpreted to safeguard the interest of the rich and affluent land owners who have acquired the land from scheduled caste. So, affluent people are benefited, scheduled caste and oppressed class people are suppressed. Women, the weak section of the society, is not protected. So, implementation of law, a rule of law is not in conformity with the governance and the constitution, is my submission to this house. It is far greater shame in a state which rests upon law that there should be a departure from law, for law is the bond which secures our privileges in the Commonwealth, the foundation of our liberty, the fountainhead of justice. The state without law would be like the human body without mind. The magistrates who administer the law, the judges who interpret it, all of us, in short, obey the law in order that we may be free. Magna Carta was referred to by Jayaprakash Narayan. Magna Carta propounded the notion that no person, including the sovereign, is above the law, and that all persons shall be secure from the arbitrary exercise of the power of the government. As such, the Magna Carta is called the spiritual and legal ancestor of the concept of rule of law. It acted as a constitution, as a higher kind of law against which the legitimacy of later laws and policies could be tested. Further, Chief Justice Coke asserted the power of the courts to decide the legality of the laws and legitimacy of governmental actions on the touchstone of the common law. This is not happening in this country. The arbitrary exercise of power by the legislature in enacting the law, the arbitrary nature of power exercise by the political executive and the executive, the bureaucracy in this country, and interpretation has been made by Supreme Court in a number of cases. From Chokkalingam's case, 1974 is the second dimension of Article 14. Chokkalingam is a Chief Secretary of Tamil Nadu State. The discrimination is not only the concept of Article 14. Arbitrariness and unreasonableness is the concept of Article 14. That is the second dimension of Article 14. The third dimension in Maneka Gandhi's case, 1978, Supreme Court impounding the passport. So I am not on that point. So the arbitrary exercise of power is rampant in this country. The classic case in this state is the recent government order number 1 in this country, in this state, that runs contrary to Article 19. 1861, Section 30, 31, 31A, you incorporate and issue the government order. It is a government order for all the time to come. That kind of government order prohibiting freedom of speech, freedom of assembly is not permissible. This is what Supreme Court has said in a number of cases. This is the blatant violation of the executive power by the political executive and the legislature. That is not permissible at all, is my submission. The Supreme Court India's conceptualization of rule of law, the concept of rule of law runs like a golden thread through the entire fabric of the Constitution of India 1950. It is pertinent to analyze how the Supreme Court of India has interpreted and constructed the concept of rule of law in order to understand the kinds of restrictions imposed on powers of the legislature and executive. In essence, these restrictions are in the form of negative and positive obligations imposed on the legislature, rule making and executive rule implementing powers. The excessive exercise of legislative power, which is not with you either from the list 1 or list 3 insofar as the state is concerned, the parliament is concerned, the parliament is concerned, list 2 and list 3 insofar as the state legislature are concerned. The classic case is the UPA, that is unlawful prevention of, the case is filed against the Kapan, the charges made, the charges are, do not attract the UPA Act. He has been deprived the freedom of movement guaranteed in Article 19 of the Constitution of India. He languished in jail for 2 years. Forget about this person. There are persons who are poor, who are agricultural laborers, who are the pavement dwellers. There are a number of people on flimsy charges languishing in the jail more than the imprisonment period provided under the Indian Penal Code. This is one way law is enacted, exceeding your legislative power, and invoke that power by the executive, keeping them under the judicial custody, institute the cases, no charge sheet will be filed, no investigation is made, and lakhs of people are languishing in the jail, blatant violation of the human rights of these people. This is happening. This is not the rule of law in a democratic country. In Keshavananda Bharati's case, way back in 1974, Keshavananda Bharati, Sripada Galavaru and others, this is from state of Kerala and another, the majority of the judges of the Supreme Court, while declaring the rule of law is part of the basic structure of the Constitution of India. Basic structure shall not be amended is the judgment of Keshavananda Bharati, still holds the field. We have heard, we have seen in the television, the constitutional authorities with the due disregard to the binding precedent under Article 144. Law of the Supreme Court is binding under Article 144. All the authorities, all the persons in blatant violation which has in force for the last more than 55 decades, you are telling today this is not the correct statement of law. How can you tell that? It is binding on you. It may be possible. It is the basic structure cannot be challenged, cannot be amended. A restricted power, legislative power under Article 368 is the judgment of Keshavananda Bharati's case. Now, the persons who are in power, under the garb of that power and the protection of the power, in the house, outside the house, you are speaking, that means you are you are taken the oath under the Constitution that I will be abide by the constitutional principles and the law of this country. You speak against the law, what it means. So this is not correct. Our Constitution is conceived a radically different tradition. Our forefathers did not believe in the acquisition of things pleasure. They stood for the good and the wholesome. They addressed their king as Rajan because it was his duty to secure the welfare of his people. We are not in a monarch rule. We are in a democratic rule. Constitutionalism, constitutional democracy, it has given a go by today. The monarch rule is better than the constitutional governance today. That's what the feeling of the people of this country. And you don't have right to express. You don't take the procession, rally. What kind of this? Is this permissible? As rightly pointed out, it is not the persons who have come into the political party get majority in the general elections. You, under the People Representative Act, constitutional mechanism, constitutional principles, you persons who have got majority political party or the other political parties who are coming to affiliation at the time of election or after the election, you form a government, should you not allow the government opposition party to function? Should you not allow the opposition party leader to make his case in the floor of the assembly? Has he no right? The constitutional position he holds. The policy of the government is entitled to criticize for good governance. What is wrong with that? You criticize in the assembly. It is going on. You will not allow the opposition party members to debate on important the topics, the bills which have been introduced. The money bill, just like that, whether it is money bill or not, electoral bonds, retroactive effect, electoral bond bill, under the money bill it has been introduced. Is it permissible with the constitutional scheme? Is it permissible to introduce the law? 3 laws have been enacted. Farmers, 1 year the farmers have gone on strike in Delhi. So bills were not debated. Bills were not sent to the joint committee. Is it the good governance? Is it the rule of law? Is the question for the 140 crore people are required to question the people who are in helm of affairs. That's the point. And further, how many people died? Hundreds of people died. Who is answerable for this? Answerable, the persons who are in governance, they are answerable for this. Why did you enact the law? Why did you repeal the law? You have accepted the protest, strong protest, on more than 365 days. You have withdrawn the laws. That means those laws have not been given effect to, that is not properly implemented. There was a protest, strong protest, that is because Article 19 of the Constitution of India. So that is what is happening in this case, in this country. In view of the above reasoning, the issues arises, how does the state justify its policy giving tax subsidies to the rich corporates and simultaneously citing lack of revenues are the primary reason for not fulfilling its obligation to provide social welfare benefits to the poor tribal population. See, this is a malady in this country. You give the land, you acquire the land, you give the subsidy of the contract, this current, you give all subsidies. Yes, we are requiring the industrial revolution in this country, but not at the cost of the poor man, not at the cost of the other citizenry of this country. Now, another malady is the GST. Common man required to pay central government sales tax when the law is, when the food is sold. The earlier period, Central Sales Tax of 1957, interstate sale takes place, then only the tax required to be paid to the central government. Today, whether interstate, no interstate transaction, the food you eat, indirect tax, millions of rupees are being required to be paid to the central government. This is the arbitrary exercise of legislative power, and that is not good. For want of time, I am speeding my the speech. I am not giving the details. Further, the apex court in Keshwananda Bharti's case noted that Constitution postulated the rule of law in the sense supremacy of the Constitution and the laws opposed to arbitrariness, cautioning the state against making arbitrary laws and policies. The court observed whereas it is essential, if a man is not to be compelled to have recourse as a last resort, the rebellion against tyranny and oppression, that human rights should be protected by the rule of law. In the light of court's reasoning, poignant question that emerges, what option does the poor tribal population have against the state unjust laws and policies that exclusively in favor of rich corporate and violate the tribal citizens' fundamental rights? Later in Indira Nehru Gandhi's case, Rajanarayan, the court observed, this is 1975, the concept of rule of law was not like a twinkling star above the Constitution, but was a terrestrial concept which had its habitat within the four corners of the Constitution. While reasoning of the rule of law is that rule of law is the basis of democracy, the court observed the rule of law postulates the pervasiveness of the spirit of law throughout the whole range of government in the sense of excluding arbitrary official action in any way, any sphere. The rule of law is based upon the liberty of the individual and has its object and harmonizing of opposing notions of individual liberty and public order. The notion of justice maintains the balance between the two, and justice has a variable content. In Jaisinghani's case, Union of India and others, the court, while prescribing the conditions that govern the executive exercise of discretion, observed, I quote, the absence of arbitrary power is the first essential of the rule of law upon which our whole constitutional system is based. In a system governed by rule of law, discretion, when conferred upon executive authorities, must be confined within clearly defined limits. Where discretion is absolute, man has always suffered. It is in this sense that the rule of law may be said to be a sworn enemy of caprice. Discretion, as Lord Mansfield stated, means sound discretion guided by law. It must be governed by rule, not by humor. It must not be arbitrary, value and fanciful. The judgment, Raman Dayan City's case, I will skip on. Now, I would like to say, rule of law is violated in Andhra Pradesh state. Certain cases which I refer, which is within my knowledge. The capital city land scheme. Just a minute, please. I know it. I am aware of it. President is not given missile. Please bear with me. Capital city land pooling scheme. The breach of contract. Is the contract is breached. Denial of fundamental rights. Farmers of Amravati is the classic case. There are 307 cases are foisted against the farmers. It is violation of the rule of law by having protested and dharna, rallies were taken, 307 cases were filed, executive exercise and arbitrary exercise of power. Police state, literally police department, to be specific, some selected police officials are running the state. He is like private army of ruling party. SC component funds are diverted, contravening the provisions of Subplan Act of AP. The Andhra Pradesh scheduled caste students required to study the policy, budget is earmarked, that they have not been given. And natural resources are looted brazenly. Here, the minor mineral of sand, governed by the regulation, the blatant violation of that, it is taking place. And the political activity of the opposition parties is stifled. Either any political party leader, I have seen in the TV in Visakhapatnam and in other places, the opposition party leaders, political party leaders are not allowing the police officer, asking him to sit down in the car, not allowing to rise. This is the blatant violation of the rule of law. Thank you very much.